Shall we start?
Yeah, cancellation of instruments has always been a topic which also touches the common man as well as the lawyers, needless to say. There's a lot of march of in this particular aspects. Today, in fact, one of my friend had shared the latest judgment or even as to whether for the purposes of cancellation of an instrument, whether you can proceed under the Civil Court or Arbitration Act. That judgment can be shared later on. But today we are obliged that Mr. Shangar Murali has acceded to our request to share his knowledge. And we all know that Shangar Murali and Adi Lakshmi ma'am have been always a good resource persons where people love to hear him. Without taking much time, since there was some glitch with the YouTube, I request Mr. Shangar, a dear friend of mine, to take over the session.
Thank you, sir. Good evening to all. The topic is cancellation of instruments. Often there is a confusion among the lawyers. When we want to file a suit to set aside the document or any instrument, whether a suit for setting aside the instrument is sufficient, or we can file a suit for declaration to declare that the document is illegal, null and void. The reason is very obvious. If you want to file a suit to set aside the instrument, necessarily you have to pay court fees on the amount mentioned in the document, which is ought to be cancelled. But if you want to file a suit for declaration, you can value the subject matter tentatively and you can pay the court fees. Court fees will be lesser in a suit for declaration. When a suit for declaration will lie, when a suit to set aside an instrument will lie, this is often confusing questions. Now, let us see the nuances and the intricacies of Section 31 of the Specific Relief Act, which deals with when cancellation may be ordered. This section is based on the maxim quo timet, that is, for fear that the instrument, agreements, securities, deeds may be vexatiously or injuriously used against the person who wants to avoid it. Three conditions have to be satisfied before invoking Section 31 of the Specific Relief Act. Number one, that the instrument is void or voidable. Void or voidable. Then the plaintiff must show that he has reasonable apprehension that the instrument, if left outstanding, it may cause severe injury to him. And the court may exercise its discretionary power to set aside or deliver up or cancel the instrument. So unless these conditions are satisfied, we cannot invoke Article Section 31 of the Specific Relief Act. Then, who can file a suit to set aside an instrument? The word employed in Section 31, any person, whether the term any person is an inclusive definition or not. But in strict sense of Section 31 of Specific Relief Act, the word any person does not include a third party. A third party to an instrument cannot maintain an action to set aside the instrument. It is restricted to a party to the written instrument or any other person who can bind such party or any persons claiming right derived title from the party. It includes a person seeking derivative title from his vendor or seller. Suppose I have not at all executed a document, but it affects my right or title about the property. What is the remedy available to me? Because I am not a party to the written instrument, so I cannot maintain an action under section 31. But I am not remediless. My remedy, that is the non-execution of the instrument, is to file a suit for declaration under section 34 of the Specific Relief Act. So this is held by our Honorable Supreme Court, 2021 4 SEC, page 786. Deccan Paper Mills Company versus Regency Mahavir Properties, 2021 4 SEC, Supreme Court cases, page 786. Then, whether an action instituted under section 34 of the Specific Relief Act is an action in rem or action in persona. You are aware that a right in rem is a right exercisable against the world at large, whereas right in personam is an interest protected solely against specific individuals and determining the rights and interests of the party themselves in the subject matter of the case. Therefore, an action instituted under section 31 of the Specific Relief Act is an action in personam. Is an action in personam. Asian Avenue Private Limited versus Syed Chaukat Hussain, 2023 SEC online Supreme Court page 514. 2023 Supreme Court cases online Supreme Court page 514. The next question, what is the court fees payable in a suit to set aside the instrument? That is a very big issue. Suppose if, I think we are in Tamil Nadu and Andhra, we are having our separate statute known as Tamil Nadu Court Fees and Suit Valuation Act. But I know that in Punjab and Haryana, you are following the Central Act, Court Fees Valuation Act. And when you want to file a suit for partition and when you are out of possession, you have to pay court fees on the market value of the subject matter. Market value of the subject matter. If you want to buy market value of the subject matter, but to set aside the sale, to set aside any instrument or deed, in section 40 of the Tamil Nadu Court Fees and Suit Valuation Act and section 37 of the Andhra Pradesh Court Fees and Suit Valuation Act, the word employed is value of the property. It does not deal about the market value of the property. So market value of the property, there are specific sections wherein you have to pay court fees on the market value of the property. Market value of the property. Whereas in a suit to set aside the instrument, the proper court fee is on the amount mentioned in this document, which is sought to be cancelled. You need not worry about the market value of the property. Document may be executed 2 years prior to that, prior to the filing of the suit. At the time of filing of the suit, its market value will be increased. But we need not worry about it. We have to value the subject matter of the suit on the amount mentioned in this document or instrument, which is sought to be cancelled or set aside. So the proper court fee is on the amount mentioned in the instrument sought to be set aside. This has been held in 2014 Polamar Setti Manikam versus Tikla Venkata Ramaya, 2014 5 SEC, page 603. 2014 5 SEC, page 603. Then next point, what is a period of limitation to file a suit to set aside instrument or set aside a degree? Article 59 of the Limitation Act says 3 years. When the facts entitling the plaintiff to have the instrument set aside first become known to him. When he came to know about that this document is left outstanding would cause serious injury. For example, you entered into a sale agreement. You are the vendor. You entered into a sale agreement with your purchaser. Received certain amount as advance, and further balance payment has to be paid within a period of 3 months or 6 months, whatever it may be. The purchaser didn't turn up during the currency of the sale agreement. So there is a delay. If it is a registered instrument, you cannot sell the property in favor of others because your entry shows that there is a registered sale agreement. Then you have to file a suit to set aside the registered sale agreement on the ground your purchaser failed to perform his part of obligation within the stipulated time. If the sale agreement is allowed to be left outstanding, it would cause severe injury because you may not be in a position to sell the property. So under those circumstances, you can invoke section 31. But here the period of limitation is 3 years from the date when you came to know that the defendant, that is your purchaser, failed to perform his part of obligation. From the date within a period of 3 years. 3 years. Now, in one case, father executed a registered gift deed in favor of his son, and another son wanted to impeach the said gift deed, and he has filed his objection before the revenue officials not to mutate the name of the donee in the revenue records. But he has filed the suit after the expiry of 3 years from the date of mutation order. Then the court has held that the suit is barred by limitation, hopelessly barred by efflux of time. Abdul Rahim versus H.K. Abdul Jabbar, 2009, 6 SEC, page 160. Then, in the case of involvement of minors' interest in the property, suppose minor's property is sold, what is the remedy available to the minor? Minor has two options. One, he can file a suit within a period of 12 years to recover the property under Article 65. Or he can file a suit within a period of 3 years of attaining majority under Section 60 of the Limitation Act to set aside the sale. To set aside the sale which affects his interest over the property. This is 2006 by SEC, page 353. 2006 by SEC, page 353. Now, another question that is often asked question. Suppose in case of registered instrument, can it be set aside? Then what is the presumption? Section 60 of the Registration Act, under Section 60 of the Registration Act, there is a presumption that the registered document is duly executed and registered. Of course, it is a rebuttable presumption. You want to attack the registered written instrument, then onus of proof is on you to lead evidence that to rebut the presumption. Rebut the presumption under Section 60 of the Registration Act. Brahim Singh and others versus Birbal and others, 2006 by SEC, page 353. Then Section 31 deals with void or voidable document. Another important question is, when a document which is void on the face of the record, can it be adjudicated as a void document? Suppose you are the owner of the property. Some third party, by forging a signature, executed a sale deed in favor of third party. You are not a party to the document. There is some fabrication or impersonation. Whether such a sale deed affects your title to the property, when especially you are not a party to the document. So far as you are concerned, the document is void on the face of the record. You can just discard it. You need not file a suit to set aside the document, because the document itself is void on the face of the record. You can just discard it. If you want to cancel it, you can file a suit for cancellation and not to file a suit to set aside the sale deed, because since you are not a party, party to the instrument, you can very well file a suit for declaration by tentatively value the subject matter of the suit. If you want to file a suit to set aside the sale deed, you have to pay the court fees on the amount mentioned in the documents are to be impeached. Void property conveyed by a person who had no title, then such a document would be void. This is because of the maxim, no one can have a higher right over the property than he does. Nemo dat quod non habet. Such a void document need not be declared by the competent court that the document is void, because document itself is void. There is a question of declaring again it as void document. It will not bind the parties. But instruments obtained by misrepresentation, fraud, or undue influence, then these instruments are voidable documents. You kindly refer section 18, 19A and 19 of the Indian Contract Act. For example, you availed a loan, you wanted to execute a mortgage deed in favor of your mortgagee. But mortgagee, instead of registering the mortgage deed, registered a sale deed. Registered a sale deed. You are a party to the document. You are a party to the document. You are party to the document, you are challenging the nomenclature of the document. Then it is a void document. You can file a suit for declaration to declare that the sale deed is illegal, null and void, because I intend to execute only mortgage deed, but it was registered as a sale deed. So the burden of proof is on you to prove that fraud was played on you or misrepresentation was made, undue influence was exercised. Assuming for a moment that you are an illiterate person, not possessed with sufficient worldly affairs, you want to impeach a document executed by you, then the burden of proof is on the person who obtained the document. The burden of proof is not on you. This is a peculiar character. This is peculiar. It is applicable only to the person who are illiterate or not possessed with sufficient worldly affairs. The burden of proof is not on the plaintiff who instituted the suit to set aside the instrument under section 31. Burden of proof is on his adversary. So, void document person who had no title, the document on the face of the record is void. It will not confer any title. So you can just discard it. You need not file a suit to set aside the void document. Whereas in the case of voidable document, you may be the party to the document and you are challenging the recitals in the document. Then it is a voidable document. Necessarily, it has to be set aside by taking recourse to section 31 of the Specific Relief Act. Because fraudulent misrepresentation in respect of character of a document is void. Fraudulent misrepresentation in respect of character of the instrument is a void. But when it is in respect of contents of the document, it is void. It is void. If it is voidable, necessarily you have to seek the relief to set aside the same. If it is void, you may or may not file a suit for declaration. This is the very same judgment 2006, 5 SEC, page 5353. Suppose if any instrument is affected, it affects what right over the property or title over the property. That instrument was executed by the person competent to execute. Then what is the remedy? Your remedy is to set aside the instrument. Suppose you are one of the co-passionate. Your father executed a sale deed, not for any legal necessity. We can impeach the sale because Karta is competent to execute sale deed. But it affects your right because the sale is not for any legal necessity. You can impeach it. But your remedy is to file a suit to set aside the sale deed, and you cannot file a suit for declaration that the sale is illegal, null and void, not binding on you. Because the person executed the document is competent to execute it, but at the same time your right is affected, then your remedy is to take recourse under section 31 and not under section 34 of the specifically required. This is Chaco versus Mahadevan, 2007, 7 SEC, page 363. Then, assuming for a moment there are co-sharers. Co-sharers in joint possession. But one of the co-sharers executed a sale deed including the off share of the other co-sharer. Now it came to know that one of the co-sharers who has not executed a sale deed came to know that his share was also conveyed by the other co-sharer. Then what is the remedy available to him? Whether he can file a suit for declaration to declare that the sale deed executed by the other co-sharer conveying his property is illegal, null and void, or he can file a suit to set aside the sale deed on the ground that his share was also conveyed. He has no better title to convey your property. Then what is the remedy? You can just ignore the sale. You can just file a suit for declaration, suit for partition. That is enough. That is enough. Because the document on the face of the record is void. The person who has executed the sale deed is competent only to execute his share is concerned, not in respect of your share. So, to that extent, the document is void so far as you are concerned. You can just ignore it and you can very well file a suit for partition of your share in the property. This is 2022, One Law Weekly, page 241, Supreme Court. Keval Krishnan versus Rajesh Kumar and others, 2022, One Law Weekly, page 241. Then, another important aspect, so far as section 31 of the specific leave act is concerned, whether unilateral cancellation of sale deed is permissible. In Satyapal case, our Honorable Supreme Court said unilateral cancellation of the sale deed is permissible. Then it shocked the entire legal fraternity. How it could be? Sale deed is, you know that it is a bilateral document. Without the knowledge of the vendee purchaser, how the vendor is bold enough to cancel the document even after receiving the sale consideration without your knowledge? But in that case, Satyapal case, the facts are entirely different. A property, a conveyance deed, a sale deed was executed by the cooperative society registrar secretary in favor of the allotee. There is a condition in that allotment that the allotee has to put up construction within a period of 2 years from the date of allotment. If no construction is made by the allotee within the stipulated period, then the society has got power to cancel it unilaterally. So, based on this specific covenants, our Supreme Court has held that there is a covenant. Parties to the agreement are bound by the terms and conditions of the agreement. So, the unilateral cancellation of the sale deed by the society, by the cooperative society, secretary of the cooperative society is correct, and the suit filed by the allotee to cancel the unilateral cancellation of sale deed was dismissed. But that is on entirely on different footing. But once a sale deed is executed, registered, it can only be impeached by filing a suit to set aside the sale deed. Set aside the sale deed. There cannot be any unilateral cancellation of sale because it is a bilateral document. Bilateral document. Previously, under the Registration Act, any document is presented for registration, the registering authority will receive it and just he has to verify whether the proper stamp duty is paid or not. If it is okay, then he will register the same unmindfully. But after this Satyabal judgment, in Tamil Nadu, amendment was made in the Registration Act that a sale deed which was duly executed and registered can only be cancelled by both the vendor and vending. There cannot be any unilateral cancellation. Amendment now is made. So, unilateral cancellation of sale deed is impermissible. Tota Ganga Lakshmi versus Government of Andhra Pradesh, 2010, 15 SEC, page 207. Because the full bench of the Honorable Andhra Pradesh has held that unilateral cancellation of sale deed is permissible. Because there is no provision under the Registration Act debarring the registering authority from registering the cancellation of sale deed submitted by the vendor, seller. So after this judgment, amendment was made, but our Honorable Supreme Court has held once a document is bilateral, it cannot be unilaterally cancelled. As I said earlier, sale deed executed by Karta, not for legal necessity, you can file a suit for declaration to declare that the sale is illegal, null and void, not binding on. This is 2020, 14 SEC, page 436. Then another important point. You are all well aware, a person in settled possession, even if he is a trespasser or an encroacher, can only be evicted in a manner known to law. He can only be evicted by taking recourse to the due process of law or recourse to law. This is well nigh principles of law. Person in settled possession, even if he is a trespasser, his possession cannot be disturbed without taking recourse to the due process of law. But what is the meaning of the word due process of law? Suppose suit for declaration has been filed and for the consequential relief of injunction, restraining the defendant from interfering with the plaintiff's peaceful possession and enjoyment of the suit property. Suit for declaration and for the consequential relief of injunction. The court comes to know that the plaintiff has no title to the property and it believed the title of the defendant. After overall assessment of both oral and documentary evidences, the court came to a conclusion that the plaintiff has miserably failed to establish title to the property and the title of the defendant is proved. Then automatically declaratory relief can be dismissed. But if it is found that the plaintiff is in possession and enjoyment of the suit property, whether the court is entitled to dismiss the declaratory relief and grant a consequential relief or permanent injunction, this is the point for consideration. Because the court finds that the plaintiff is in possession. So his possession cannot be disturbed even by the true owner forcibly. The true owner has to file a suit for recovery of possession. That is the law. But our Supreme Court recently held, once the rights of the parties are adjudicated in a case, plaintiff's title is not proved, so he is not entitled to get a degree for declaration. But even if he is in possession of the property, he is not entitled to get an order of injunction. This is because when the substantive relief is declined, the consequential relief cannot be granted. The consequential relief cannot be granted. Even if the plaintiff is in possession and enjoyment of the suit property, once the court adjudicated his title over the same, that the plaintiff has no title to the property, the the granting a degree in respect of injunction has to be set aside. So that was done by our Honorable Supreme Court in the case reported in 2022 12 SEC page 128. 2022 12 SEC page 128. This is very important judgment. Now, I have come across 30 years of practice. I have seen so many cases. Even if title is not proved, if the plaintiff is found to be in possession of the property, invariably the court has granted the degree for permanent injunction, even though it dismissed the declaratory relief. But that is not the correct proposition of law. Our Supreme Court said, once adjudication is made by the court with respect to the title of the party, then even if he is in possession, he is not entitled to get an order of injunction. 2022 12 SEC page 128. Then whether an unregistered document can be cancelled. Section 31 does not say that the registered instrument alone can be cancelled. So even an unregistered document, if you feel that if it is allowed to be left outstanding, could cause severe injury and irreparable loss to you, you can very well file a suit to set aside the instrument which is not a registered instrument. Then what is the procedure after the cancellation of the instrument? So yet after the degree is passed, setting aside or cancelling the instrument, then section 2 of subclass 2 of section 31, the court has to send its degree copy to the concerned subregistrar to make an entry in book 1 that the document is cancelled. Because unless the entry is made that the document is cancelled by the competent court of law, then there is a chance of encumbering the property. Then the right third party's right, innocent bona fide purchaser's right will be prejudiced. So cautiously our legislature has drafted section 31, wherein that subclass 2 says once once an instrument or degree is set aside, and if it is registered, then the court must send the copy of its degree to the concerned subregistrar to make an entry in book 1 or in the relevant book maintained by it. Whether an instrument can be partially cancelled or partially uh, allowed to be enforced. Yes, it can be. Suppose the document contains two separate description of properties. So far as one item of property, if you want to avoid it, you can file a suit to set aside the instrument only in respect of those property which affects your title or right over the property. So partial cancellation of the instrument is also permissible under section 31 of the specific relief act. Then section 33 deals with the payment of profit or compensation. Suppose the document was set aside. For setting aside the document, it consumes certain time limit, 5 years or 10 years. But the person in possession has derived profit. It is resembling like section 2 subclass 12 of the CPC, which contemplates the payment of mean profits. Mean profit means a profit earned by the person in wrongful possession. So after setting aside the instrument, if the party enjoyed any benefit, then he has to pay such a profit to the party affected. When it is not possible to ascertain the mean profit, then the court may award compensation for the loss sustained by the person who has filed a suit to set aside the instrument and obtained a degree to set aside the instrument. So, section 31 is very small subject, but it involves a lot of legal nuances. So, document which is void, it need not be declared as void by the competent court. But if it is left outstanding, then you can file a suit to set aside the instrument which is void. If it is voidable, obtained by fraud, misrepresentation, undue influence, then it can be challenged by way of filing suit to set aside the instrument. So limitation period is 3 years, and the court fee is on the amount mentioned in the document, not on the market value of the property. So after setting aside the instrument, the court has to send its degree copy to the concerned sub-registrar to make an entry. And the court is also entitled to award compensation or order to pay profit earned by the person in whose name the instrument was executed and which was subsequently cancelled by taking recourse to Section 31 of the Specific Relief Act.
Yeah.
Because the
Yeah, thank you, Shangarji.
Session over. Very small subject, but of course, I think it will be very useful to all the participants.
They say that though it is a small section, but it has layers within layers to understand this thing. So the judgment which we said at the first instance.
I will forward the copy. I will already draft that. I will forward the copy. You can post it.
Yeah. The judgment which we said that in respect of Section 31, and if there is an arbitration clause.
Yeah, just read the latest judgment. Arbitration clause, I have also seen the latest judgment. The Supreme Court said the power to set aside any instrument sale deed is well within the domain of the competent civil court. The arbitrator has no right to set aside the registered instrument. That is the judgment. Because the power to cancel, the power to set aside instrument can only be made by the court, by the competent civil court, and not by any arbitrator. Or even tribunal has no power to set aside the instrument which was registered. It can only be cancelled or set aside by the court on the specified grounds by taking recourse to Section 31 of the Specific Relief Act. That is the latest judgment of the Supreme
Court. So thank you, Mr. Shangar, and thank you, though Adi Lakshmi has not joined, for helping us to connect to such a good, resourceful person, and the team of Legal Elites. So do stay connected with Beyond Law CLC team on the WhatsApp. Yeah, thank you. Namaskar.
Thank you.